The county sheriff, a constitutional officer. The county sheriff is a constitutional officer elected by the people, bound by oath, as guardian of the people's unalienable rights secured by the Constitution, the United States Constitution, and its capstone Bill of Prohibition is the law of the land, and all statutes and state constitutions repugnant to the United States Constitution are null and void. If the sheriff is ignorant to the Constitution, it would stand to reason that he is in violation of his oath, not knowing when judges and politicians violate the law, and thereby technically guilty of treason. United States Constitution, Article 6. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. Marbury versus Madison. All laws, rules, and practices which are repugnant to the Constitution are null and void. Law of the land, due course of law, and due process of law are synonymous. People versus Skinner. Western Union Tel Company versus Call Publishing Company. Common law as distinguished from law created by the enactment of legislatures. The common law comprises the body of those principles and rules of action relating to the government and security of persons and property, which derive their authority solely from usage and customs of immemorial antiquity, or from the judgment and decrees of the courts recognizing, affirming, and enforcing such usage and customs, and in this sense particularly the ancient unwritten law of England. Houston versus Langston. Sheriff is the chief executive and administrative officer of the county chosen by popular election. His principal duties are in aid of the criminal and civil courts of record, in other words, common law courts, such as serving process, summoning juries, executing judgments, holding judicial sales, and the like. He is also the chief conservator of the peace within his territorial jurisdiction. The sheriff, being the chief law enforcement officer and highest peace officer of the entire county in which he was elected to secure the peace, unlike the state police and municipal police being code enforcement officers serving the corporation and not the people, in a conflict of interest having no constitutional authority or concerns, whereas the sheriff reports directly to the people and not the corporation. The duties, responsibilities, and authorities of the county sheriff are at minimum the same as they were when the state constitutions were originally written. The duties, responsibilities, and authorities of the sheriff cannot be diminished by the legislature, courts, and state constitutions. When it comes to enforcing the law, the sheriff, being the chief law enforcement officer, answers to no one, not even the governor. Like any other elected official, the sheriff cannot be removed from office by another elected official. He can only be removed by the people at the ballot box, or by an indictment or presentment by a grand jury. If the sheriff needs to consult a judge or bureaucrat to know when they exceeded their authority, it's no different than consulting with the fox concerning the hen house. Lysander Spooner, in Trial by Jury, 1852, said, "Any government that is its own judge of and determines authoritatively for the people what are its own powers over the people is an absolute government, of course. It has all the powers that it chooses to exercise. There is no other, or at least no more accurate definition of despotism than this. On the other hand, any people that judge of and determine authoritatively for the government what are their own liberties against the government of course, retain all the liberties they wish to enjoy. And this is freedom. At least it is freedom to them, because although it may be theoretically imperfect, it nevertheless corresponds to their highest notions of freedom. If the sheriff cannot ascertain if the government is violating the rights of the people without asking the fox, how can he perform his duty? Constitutional officer versus code enforcement officer. The principal challenges to the sheriff are code enforcement officers. Statutes that control the behavior of people are repugnant to the Constitution and are therefore null and void, while the sheriff has a duty to uphold the Constitution. This poses a sharp contrast, seeing he must obey the following United States Supreme Court rulings and Constitution in order to uphold his oath. Shearer versus Cullen. For a crime to exist, there must first be an injured party. There can be no sanction or penalty imposed upon one because of the exercise of a constitutional right. Bonnet versus Valliere. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since its unconstitutionality dates from the time of its enactment. In legal contemplation, it is as inoperative as if it had never been passed. Since an unconstitutional law is void, the general principles follow: that it imposes no duties, confers no rights, creates no office, bestows no power or authority on anyone, affords no protection, justifies no acts performed under it. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operate to supersede any existing law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Cruden versus Neal. Every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Mugler versus Kansas. Under our system of government, upon the individuality and intelligence of the citizen, the state does not claim to control him, except as his conduct to others, leaving him the sole judge as to all that affects him. Bennett versus Boggs. Statutes that violate the plain and obvious principles of common rights and common reason are null and void. Davis versus Weschler. The assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Murdoch versus Pennsylvania. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution. Hurtado versus California. The state cannot diminish rights of the people. Miller versus U.S. The claim and exercise of a constitutional right cannot be converted into a crime. Shearer versus Cullen. There can be no sanction or penalty imposed upon one because of his exercise of a constitutional right. Schwer versus the Board of Examiners. The practice of law cannot be licensed by any state. Zims versus Edherns. The practice of law is an occupation of common right. Brotherhood versus Virginia. Litigants can be assisted by unlicensed laymen during judicial proceedings. City of Chicago versus Collins. Those things which are considered as Unalienable rights, which all citizens possess, cannot be licensed, since those acts are not held to be privileges. Thompson versus Smith. The right of the citizen to travel upon the public highways and to transport his property thereon, either by carriage or by automobile, is not a mere privilege which a city may forbid or permit at will, but a common right which he has under the right to life, liberty, and pursuit of happiness. Gormlin versus Lightfoot. Constitutional rights would be of little value if they could be indirectly denied. Simmons versus the U.S. We find it intolerable that one constitutional right should have to be surrendered in order to assert another. Miranda versus Arizona. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Shuttlesworth versus Bingham. If the state converts a liberty into a privilege, the citizen can engage in that right with impunity. Yick-Wo versus Hopkins. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, where sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all governments exists and acts. And the law is the definition and limitation of power. For the very idea that man may be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another seems to be intolerable in any country where freedom prevails, as being the essence of slavery itself. First Amendment. Congress shall make no law respecting or establishing of religion or forbidding the free exercise thereof. First Amendment. Congress shall make no law abridging the freedom of speech. First Amendment. Congress shall make no law abridging freedom of the press. First Amendment. Congress shall make no law forbidding the right of the people peacefully assemble. First Amendment. Congress shall make no law forbidding the free exercise to petition the government for redress of grievances. Second Amendment. A well-regulated militia, being necessary to the security of a free state, shall not be infringed. Second Amendment. The right of the people to keep and bear arms shall not be infringed. Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Fourth Amendment. No warrant shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or thing to be seized. Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or an indictment of a grand jury. Fifth Amendment. No person shall be subject for the same offense to be twice put in jeopardy of life or limb. Fifth Amendment. No person shall be compelled in any criminal case to be a witness against himself. Fifth Amendment. No person shall be deprived of life, liberty, or property without due process of law. State of emergency. It is the sheriff's job to maintain order and peace in their county in a state of emergency, not the federal government, and certainly not the armed forces. Nor does the federal government have the authority to call martial law. Martial law has only been applied in occupied countries in order to subvert the will of the people. The sheriff has the authority to call the militia, we the people, to assist him in extraordinary circumstances, called posse comitatus. The county belongs to the people, and in an emergency we the people need to come together under the sheriff to secure our county, not hand it over to foreign powers. Posse comitatus. The power of the force of the county, the entire population of a county above the age of 15, which a sheriff may summons to his assistance in certain cases, as to aid him in keeping the peace, in pursuing and arresting felons. Bill of Rights, Amendment 2, states, "A well-regulated militia being necessary to the security of a free state shall not be infringed." Therefore, the sheriffs, being the chief executive, administrative, chief law enforcement officer, and highest peace officer of the entire county in which he was elected, has the absolute authority to arrest even the governor or a judge, and then call the grand jury directly for an indictment. He need not get permission from the district attorney. America runs on fiction of law. Ryan versus Motor Credit Company. Something known to be false is assumed to be true. Fiction of law. Hoke versus Henderson. That statute, which would deprive a citizen of the right of the person or property without a regular trial according to the course and usage of common law, would not be the law of the land. Our elected servants are out of control. America operates on fiction of law, and it is the duty of the sheriff, working with the people, if necessary, to protect the unalienable rights of the people by simply enforcing the aforesaid laws. Only the people can save America, and it is the sheriff's duty to lawfully protect and serve the people, educate and inform the whole mass of the peoples. They are the only sure reliance for the preservation of our liberty. Thomas Jefferson. I know no safe depository of the ultimate powers of the society but the people themselves, and if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion by education. This is the true corrective of abuses of constitutional powers. Thomas Jefferson. An enlightened citizenry is indispensable for the proper functioning of a republic. Self-government is not possible unless citizens are educated sufficiently to enable them to exercise oversight. It is therefore imperative that the nation see to it that a suitable education be provided for all its citizens. Thomas Jefferson. If a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be. Thomas Jefferson. Power of the grand jury. In a stunning 6-3 decision, Justice Anton Scalia, writing for the majority, confirmed that the American grand jury is neither part of the judicial, executive, nor legislative branches of government, but instead belongs to the people. It is in effect a fourth branch of government, governed and administered to directly by and on behalf of the American people, and its authority emanates from the Bill of Rights. United States versus Williams. The sheriff is the people's last line of defense. If the American sheriff would wake up to their aforesaid duties and work with the awakened people across America to enforce the law with arrests and indictments, we could save America from the tyrants that are destroying our American way of life. We the people are ready. Are you? Go to nationallibertyalliance.org for a free civics course, and let's return America to her roots. We the people.